report by the Charlotte Observer reveals that a Charlotte police officer who shot at a fleeing car while responding to an airport trespassing call does not have immunity. Now, this incident happened back in 2018. The decision itself kicks a 2021 federal lawsuit on the now 7-year-old use of force case back to Charlotte judges and closer to trial. In that incident, Officer Xyavier fired 2 shots at then 20-year-old Xyavier Calliste as he drove away from an airport employee parking lot that he was not authorized to be in. Now, Calliste in 2021 filed a lawsuit against the city of Charlotte and Lohr, alleging the officer violated Fourth Amendment rights protecting people from unreasonable search and seizure.
We are joined by our chief legal analyst, Khalif Rhodes. All right, so we're going back. 2018 was when this actually occurred. When judges take a look at a shooting incident, when officers are shooting at a moving vehicle, like where do judges feel like shooting at a moving vehicle? Where does it cross the line?
Imminent fear of bodily harm. I mean, that's okay. The standard. Let's start with that portion. But 7 years, let's start there as well.
Yeah.
The wheels of justice, they turn slow. I mean, this is extremely slow. After the incident occurred, you still got that time frame of 3 years, and then now waiting to get your day in court. It takes a lot of ping-ponging and a lot of back and forth. This court didn't rule based on the facts. This was more procedural, that we don't have the right to hear this jurisdictionally, right? But in terms of what the lower court said, the U.S. District Court judge said that, and his attorney said, you're attempting to Monday morning quarterback, and let me go ahead and start with that. That was what the officer's attorney said. But the judge said that you weren't, and you should have known that you weren't in fear of for a car that had already passed you. So this is key. Another key of good lawyering. His attorney was able to point to his own testimony when he talked about line by line through his deposition and through his interrogation, where he said, I shot at the vehicle and once the car already passed me. So this is a timing thing. Had he had said that the car was coming at me and then I shot it, I think we'd have a different outcome. But because he talked about this vehicle had already passed, how could you be in fear of a vehicle that's already gone past you? Now, again, his attorneys are saying you're able to look at this from, the next day, next couple months later, and be able to say, well, you should have known that you shouldn't have been fearful. The car's already passed you. Your fear level should be down at that point. But the judge didn't buy that. The judge said you testified that this car was gone, that it already went past you, and then you're shooting towards a car that is no longer coming towards you. There's no scenario that says that you should be fearful of a car that's fleeing. Additionally, they pointed to CMPD's internal investigation that believed that he also used excessive force. So I think a combination of his own words and CMPD's own investigation led to the point where now this judge the lower court judge was able to make the determination that we're not going to give you qualified immunity. And we got to also be clear what that is. That's not law. Qualified immunity is not in any statute. You won't find it in any case law. What it is it's something where courts have created this thing, this extra hurdle that you have to jump over before you can even get in the front door to file a lawsuit.
Well, so when would you get qualified immunity, and why did the officer think that he was justified in asking for it?
Well, because 99% of the time you do. That's why this case is, not to say like we've been talking about this morning, but this is unprecedented. It's rare that you see in a court, a lower court judge like this U.S. District Court judge, not stop a case for qualified immunity. Family files a lawsuit for a wrongful death claim. They rush to court to try to get their justice, and then when they're going through the process, the officer will say, hey, I was in fear, I was in imminent fear, I followed the process, I followed the standard, qualified immunity steps in. No case, you're not even able to bring it. And you want to have those things there. I'm not a fan of a blanket approach of qualified immunity, but I do think that you should have some heightened protection and some things in place for officers that are on a job that is a split-second decision. You don't want folks to be fearful, okay, I react right here, can I lose my job? Can I not be able to provide for my family? Well, at the same time, they have to balance, am I able to make it home at night? I think that's how we got to that place of qualified immunity. But I think it's ballooned to a place now where the courts didn't anticipate it, and the cases like this, it's kind of a rolling back of what's occurred over the last probably 20 years.
If we can flip this now and say you're representing this former CMPD officer, right? And you're saying, okay, the car had passed me when I started firing, but maybe I was afraid that the car would spin around. How would you defend this case? Because as we mentioned in the beginning here, this is very close to going to trial. How would you defend this case?
Yeah, I would start there. I mean, I would say that at the end of the day, that just because the car had left or had already went past me, that split-second decision. I'm not sure if he was coming back. There were a number of things that I would want to know of what led up to this person. They were in some employee parking lot. They were attempting to flee and leave the parking lot. But I would have known, did they flash a gun at you? Did they shoot something at you? Did they throw something at you? Did they attempt to hit you with the car? I mean, those would all be the things that I would want to know. But getting over the hurdle of that imminent fear, I think is twofold. It goes on top of the qualified immunity portion, but it also goes to the actual allegations of the claim. Because if you weren't in imminent fear, you had no justification to shoot, then this case is going to be hard for them to prove on CMPD in terms of defend.
All right, Khalif, thanks, man. Appreciate your time today.
Queen City News Plus. Just search Queen City News on your smart TV's app store.